so conflict resolution. How many of you have ever had a board member that you just can't get along with? Oh yeah, that hand went up pretty quick.
We've always had.
Yeah.
8
Well,
years.
are they sitting next to you? That's the big question. No? So what I'm going to talk about briefly before we end today is how to avoid conflict, if you can, and if there is conflict, how to address it. Now, there are some pre-litigation things you can do and litigation items you can do. We're going to talk about both. So here's what we're going to talk about. One, if you're managed, usually your manager goes to tons of training provided by attorneys like Scott you just heard from, like me. I'm Clint Goodman, by the way, with Goodman Law Offices. We provide training to the managers about these specific issues. We share with them the lawsuits we're encountering, the litigation we engage in, the defense arguments, what the judges are doing, so they know, oftentimes, what some of the things you can do to avoid conflict on your board. But let's just face it. Here's the next question for each of you. How many of you have had a board member that is leaking confidential information about something? Or how many of you have an issue where there is a board member who is out there cooking the books? Hopefully that doesn't happen, but it's come across my desk a few times. What do you do? Well, there's a couple of other methods. One is alternative dispute resolution. Alternative dispute resolution, you guys know what that is? By raise of hands, anyone know what it is? Want to explain it?
Explain.
So here's what it is. Your governing documents probably don't have a requirement that a board go to mediation or arbitration to resolve their disputes. But what we're starting to see is some of the governing documents are being amended to incorporate conflict resolution provisions in the documents or resolutions by the board to resolve problems. Mediation and arbitration are two of the big ones. The courtroom isn't really alternative dispute resolution. We'll talk about that later though. With mediation, a mediation is only applicable when what? When both parties agree to go and talk it out. And what happens if you don't enter into an agreement? Nothing, right? With mediation, the only way it works is if everybody agrees to an agreement. That's it. So the pro to mediation is that if you've got a bunch of people that are willing to talk about how to resolve a problem, you can go pay somebody to mediate your conflict, and it's good to go. Sometimes, though, you have your lawyers there, and it costs money. And if you don't reach an agreement, it's wasted money. So there you have it. That's the pro and con for mediation. What's the difference between arbitration, though, and mediation? Yeah. So in mediation, the parties agree as to how they're going to resolve the dispute. In arbitration, one side presents their arguments and facts, then the other side presents their arguments and facts, and the arbitrator makes a decision without regard to what the two want to decide. The arbitrator decides who's right or who's wrong and makes a decision. And oftentimes arbitration can be called it's called binding, non-appealable. Now, like I said just a second ago, you're probably not going to find these two kinds of things in your documents right now, but the trend is we're starting to see more and more of these incorporated. Any questions on those two items? Perfect. Now let's get into codes of conduct. How many of you have a code of conduct? Yeah? What does your code of conduct say? Don't discriminate. The gentleman in the back, what does your code of conduct say? Okay. Here's some popular words or phrases in a code of conduct. That the association board members shall be in good standing, not past due on their assessments, not be a violation. If you are tasked with the obligation to enforce the documents against homeowners, you yourself should be clean, have clean hands essentially. So that's what the code of conduct may say. Another provision in a code of conduct could be that once the board makes a decision, that's it. You drop it. You don't keep arguing about it after a decision is made. For those of you that have code of conduct, what does your code of conduct say about what you can do if somebody breaches it? It doesn't say anything in yours? You don't remember what yours says, but let me ask the manager in the back. You guys have seen codes of conduct. What are your codes of conduct that you've seen recently say if a board member breaches a code of conduct? Nothing? Mm-hmm. You're right. A lot of them don't say anything. So where's the teeth? Who cares? So, can you put teeth? The question really is, can you put teeth in a code of conduct? To where, let's say, there's a breach. Director is sharing confidential information, leaking it, or gave an attorney-client privilege letter to a homeowner, and the homeowner sues the association over that attorney-client privilege letter. That might be a breach of the code of conduct. Can the code of conduct say that that member has to voluntarily resign? And if that member doesn't resign, can the code of conduct say that the majority of the board can remove that individual? What do you think? Do you think a code of conduct could do that? By a raise of hands, who says yes, the code of conduct could do it? By a raise of hands, who says no, the code of conduct cannot? I want to hear some arguments for and against. So you said yes.
As long as it doesn't contradict anything already in your CC&Rs.
Okay, good answer. How about in the back? You said no. Why?
There's a statute that says for removal of board members. Has to go into membership.
That statute you're referring to, probably 33-18-13 in the Planned Community Act? Yeah, it is. It goes on to say, quote, notwithstanding anything to the contrary in your declaration, articles, or bylaws, and then members can remove by simple majority of quorum. And then you get the petition stuff that follows it, right? And so since that statute was adopted, a lot of us have been saying, maybe this is the only way that a board member can get off the board, right? Here's something interesting. Let me skip ahead. I'm going to come back to this. On board removal, there's another statute too. So one statute that we're referring to right here dealt with the member's ability to remove a board member. Did you know that the board can remove a board member? That's a statute too. But it's not in the Planned Community Act or Condominium Act. It's in the Nonprofit Corporation Act. And that statute, if you're a nonprofit corporation, says that a board can go and remove or ask a judge to remove a board member if the board can prove that member is engaging in either criminal activity or fraudulent activity. One of those two things. And then it goes on to say that if the court does agree with you and says you are in fact engaging in one of these two things, it can say, the judge can say, you can't run again for the board for up to 5 years. Which is nice. I've had several, you probably haven't had this happen in your communities, but we deal with the worst of the worst stuff. And I had, a couple of years back, 6 years ago now, a president who was actually withdrawing $10,000 from the ATM every other week. He got elected to the board, and within 3 months, he had taken all the cash out. And what is the rest of the board going to do? They have to do something. You got to get rid of this guy. So that's what we did. We removed him under the Nonprofit Corporation Act. So, or maybe you have a board member that might be cooking the books. I don't think that disclosing executive material typically is something that rises to the level of fraudulent or criminal activity that would justify a court from removing him. But it's just important to keep that in the back of your head, that if you get something very serious, you don't have to rely only on that statute you're referring to, the member removal, but you also have other remedies. Now let's go back to the code of conduct. Interestingly enough, there's another statute that deals with disqualification or qualification. This statute is in the Nonprofit Corporation Act as well. I assume all of you guys are nonprofit corporations, right? Anybody here not a nonprofit corporation? Okay, good. So you were told you're going to be getting all of our written materials via email, right? Well, you should be, because we submitted all of our written materials with all the statutes and our summaries, and they're going to be emailed over to you. This statute is in the nonprofit. It says in ARS 10-3802 that, quote, the articles or the bylaws can prescribe qualifications on directors to run. That's essentially what it says. So if you look at your articles and they say, in order to run for the board, you have to be an owner. Okay, so if you have John Doe from Subway across that's not an owner and wants to run for the board, can you exclude him from running for your board? You bet, because the bylaws say you have to be an owner, right? That's clear law. Let's say that your bylaws or articles say you have to be in good standing to run for the board. And you have somebody that submits their name to run, and they have 20 violations and owe $20,000 in fines. Can you exclude them from running? Sure, because your articles and bylaws say that you have to be in good standing. Now let me back up. They may argue they're in good standing and that they were picked on, and then there may be some sort of lawsuit that emerges from them trying to claim they're in good standing and the violations were made up. And that's life, okay? And if they're right, they're right. But let's just assume that they are truly not in good standing. You can prohibit them. If the bylaws or articles say it, the statute gives the express statutory authority to prescribe qualifications in order to run for the board. So here's the next question. The next question deals with code of conduct. What do you do if the articles of incorporation say that in order to be qualified to be on the board, you have to comply with a code of conduct? Most of your documents probably don't say that. I would be surprised if yours do. But this is something we're starting to do now when the opportunity presents itself to amend the documents to incorporate this. Can you then limit somebody from running for the board, or can they just be disqualified from being on the board if they breach the code of conduct, as long as that's in your articles or bylaws? Can you do that?
Who interprets the disqualification?
Good question.
Rules of conduct. Who determines which rules of conduct or if they violate it?
Yeah. So who determines? So let's go through an example. Board member is allegedly giving out executive material to the members that they shouldn't be doing. The remaining boards, they say, look, you're doing this. The board member says, no, I'm not. They say, yes, you are. They vote, yes, you are. Now, if your articles say that they're off because of the disqualification, and there's a dispute, and they refuse to move and say, you're wrong, I'm right, you're going to land probably in the court anyways, or just move on and let them stay on the board, right? So the purpose today is not for me to give you clear yes, no's on that issue, because we all know that there's a gray component to the law. If the board is strong-nosed about it and wants to say, yes, you were, and you're not going to be doing this, and they basically stonewall them from participating in board business at that point, if there's a lawsuit that emerges, if the judge were to decide in favor of the violation and say, yes, you were doing this, and that does disqualify you, you're good to go under the Nonprofit Corporation Act. But the facts are the facts. The judge is going to decide whether they're actually engaging in conduct that breaches it or not.
A person is running for the board the first time, never been on the board, and the board determines that ethically he's not a very ethical person. For example, I belong to a country club. We refused admission to a guy because he was a bookmaker, and he wanted to join the club because he could develop clients as a bookmaker, and the court upheld it because he wasn't ethical.
Sure. So you basically prohibited him from running for the board. You disqualified him Because he had an ulterior motive,
Because he was unethical.
right? And the court upheld it. The court likely upheld what you did for two reasons. One, it was supported by your governing documents, okay? And two, because of the Nonprofit Corporation Act statute that I'm referring to. All right? I had 2 months ago, roughly, an individual who submitted his name to run for the board. My community's annual is coming up for elections next week, okay? About 3 months ago, the manager sent this individual a notice of violation because they were parking their vehicle on the street and they shouldn't have been, because the street prohibited on-street parking on the private roadways. Clear enough, right? The individual was pretty upset, replied to the manager and said, I don't care what your bleeping CCNRs say, I'm going to continue to park on the street and we'll see you in court. By the way, please find attached my bio because I'm running for the board. Okay, in that situation, they call me, oh my goodness, Clint, can this guy run for the board? Because this is kind of scary for us. He's telling us that he's not going to abide by the CCNRs. We really don't want him on the board. Can he run for the board? What do you think the first thing is that we lawyers do when we get a question like that? What's the first thing we do? We look at the governing documents. Well, we determine whether there's a violation. Here, I think there is. I mean, he's already admitted that he doesn't care what the CCNRs say. So in my mind, I'm not really focusing on whether he's in parking on the street or not, because he said he's not. He's going to continue to violate the CCNRs. He doesn't care what they say. So my next step is to look at the governing documents and see what the articles of incorporation and the bylaws say about who can run and who can't run. And wouldn't you know, the bylaws had a provision in it that said you have to be an owner, a member, to run for the board. And then it went on to say that members must be in good standing, period. What do you think? Do you think he's in good standing? He said he's got a violation.
Even though he hasn't been fined, I think he's not in good standing.
Right, because he's got a violation. Not only does he admits to parking on the street, he didn't get a fine yet, though. So I think we're kind of in that little gray area.
Does he have to be fined in order to be a member not in good standing?
Maybe. I don't know. The case law hasn't come out yet. We don't know what that means. But the nice thing with these bylaws is it said that it defined what a member in good standing is. In the definitions section, it defined a member in good standing as a member not in good standing. It defined it as either in violation or one expressing the intent not to abide by the governing documents. Okay.
Piece of cake, right?
Yeah, right? Piece of cake. My opinion was he can't run. He's not a member in good standing. He arguably is in violation. But even if he's not fined yet, the definition of member in good standing says he's clearly not in good standing because he's expressed his intent not to abide by the CCNRs. So how can you have somebody on the board enforce the very same things they're not willing to live by? He threatened lawsuit, et cetera, didn't go anywhere after he got my letter and the citation to the statute, and we considered a closed package. He didn't run for the board. We said, please get your community, please come up to compliance, and we look forward to seeing you next year once you're in compliance and you're a member in good standing. We're more than happy to put you on the ballot then. Simple enough. All right. I think we are pretty much out of time. Yeah? Do I just have a couple more minutes on it? Because I've got some more stuff I wanted to cover. I think I had until 4:40? Okay, great. Are there any questions about code of conduct and what we just talked about with qualification versus disqualification? Yeah.
We had the code of conduct in our bylaws, and it was removed by a previous board. We reinstated them, and you ought to hear all the friction we're getting because we reinstated the code of conduct. Their argument for removing them was that they were not enforceable.
Well, I don't know what your code of conduct says, so I can't comment whether it's enforceable or not. It may very well not be enforceable. I don't know. I have to look at it. But there is this legal debate right now in the legal community about how this removal statute we just talked about earlier affects the qualification provisions in the Nonprofit Corporation Act, and whether they're both basically the same beast or different things entirely. And we just don't know yet. The Court of Appeals hasn't ruled for us. That's good news and bad news in my mind. It's good news because it tells me that all of us attorneys that are arguing that you can be disqualified and not removed means that nobody's litigating the issue. Nobody's brought it up to the Court of Appeals yet. Tells me nobody's willing to either spend the money or we're right. Okay? But the bad news is what I just said previously. Until a court, the Court of Appeals here in Arizona, defines this specific issue on the difference between removal and disqualification, you just don't know. That's the beauty of the law, is we get to say it depends a lot of time. When you get legal advice from your counsel, I'm not going to second guess his or her opinion. There are times where a code of conduct may be deemed illegal or unenforceable as a matter of law because it violates some law. I had another board just after my last class say they did the same thing because they got counsel's advice saying that their specific provision violated certain things. And my argument was perhaps, but if you focus on removal versus disqualification, qualification, it's two different things. It can be two different things. And so if you have a situation where the code of conduct that's incorporated in your articles or bylaws says that if you breach it, the member is disqualified from being on the board. And at that point, if the board stonewalls the individual from attending because they're disqualified, arguably you can. We've had that happen. I've seen judges uphold it, and not only my law firm, but other law firms. And unfortunately, we've had some judges strike it down, simply because we don't have the case law yet. Yeah.
I have a question about background checks. As a requirement for being a member in good standing, we want to do a background check. We were told that we cannot do that. By law, we can't require people to sign up for a background check.
And under both federal and state law, in order to do a background check, you have to have something. It's called a permissible purpose. So if a tow company is driving through a parking lot and starts running MVD records to find out things, they can only tap into the government databases if they have a permissible purpose. And a lot of times, the permissible purpose is okay. The statute says you can have a permissible purpose under a couple of different things. But one of them is if the person you're running the background check on agrees that you can. Consent is what the statute says. You can run a background check if you have consent. Let me switch gears for a second. How many of you have a crime-free program in your community where landlords do a background check on their tenants? A few of you? Well, whether you have it in your association or not, some landlords may have their own separate crime-free where they don't want to rent to anybody unless they pass a background check. So what do? They go to the prospective tenant and they say, I will rent you the property, but you need to give me permission to run a background check on you. And then after that, if you've met all my qualifications, then I'll rent the property to you. Okay? That's what landlords can do, and that's what a lot of landlords do.
That's legal.
You bet. It's legal. It's been around for over 30 years, and it's a internationally recognized program.
And they can charge the prospective tenant the fee for the background check.
Sure.
The landlord doesn't even have to pay.
The United States Supreme Court actually upheld it in a case called U.S. v. Rucker, or Rucker v. HUD. And the crime-free program was upheld. So we've had landlords in our communities running background checks on their prospective tenants for years and years and years and years and years. Okay? So let's take this now to our world. Arguably, if the governing documents have a provision in them that require a background check, Are you giving your consent to the background check as a member of the association? How many of you say yes? By simply purchasing the property, you're giving your consent. You're saying yes? How many say no? Got some no's back there? I want to hear why. Why do you say no?
I think it would be too risky to do something like that without them knowing exactly, because you get the documents and they're like, 40, 50 pages and they're not reading through every single thing. So I would want the signature where it says you're going to do that.
Let's say the CCNRs say that in order for you to be on the board, you have to pass a background check. Because we know in Arizona, from a Arizona State Supreme Court case called Powell versus Washburn from 2006, that it's clear that the CCNRs constitute a what? Contract. Yeah. And we also have case after case after case that says that by virtue of you purchasing property in this community, you're voluntarily entering into an agreement that you will be bound by the documents. Every time you go to closing, what does the title company provide the prospective buyer with? Everything with a statement on the top that says what? They have to do this statutorily. It's part of their disclosure packet. It says, I've received the CCNR's articles of incorporation, bylaws, and rules and regulations. I've read them and I agree to be bound by them. Signed off.
They sign for them. They never read them.
So, the courts, every time that I've litigated an issue with, I didn't voluntarily enter into a contract, this is what happens with the court. In one ear, out the other. Okay? So, arguably, I think that if you have a specific background check requirement in your governing documents, you could argue that they have permissible purpose. That's what I think, but, and there's a big, big but, I would be concerned about that provision for a couple of other reasons, okay? From a pure legal position, I think you have a good argument. But let's back up for a second. What is that going to cause in your community? First of all, I don't know of any community right now that has a background check requirement for board members. I've never seen it. So it's something new, it's novel. I bet if we did a poll of all of the FirstService residential managers here today, ask them to raise their hand, no one would raise their hand. You guys ever seen it? I haven't either. So, it's novel, it's new, and I think you're opening yourself up to a can of worms anytime you try to incorporate things that are brand new. There are other ways, there are other things you can do to help keep order in a community, other than just requiring background checks of board members. And so my advice in this case would be, yeah, there's a legal argument, but you got to be very, very, very careful. And you got to understand that if you do adopt that, there's a risk. And if you go to court, 50-50 shot, since it's so new, of the judge upholding it. And if you're okay with the risk, and you've got full disclosure from either me as your counsel or some other attorney as your counsel, go for it. See what happens. I would say, though, that you do have a duty to protect association monies. So if you already know that there's lots of chances of you guys going to lawsuit, maybe you might want to steer away from that by doing the other things that would accomplish the same goal without being so aggressive in your documents.